Good afternoon, everyone. We're just allowing folks to join the webinar, and we'll get started in just a few moments. All right, good afternoon, everyone, and welcome to today's webinar, Volatile Times and Vapor Intrusion Regulation, a legal and technical update, presented by Elie and Aldrich and Greenberg Glusker. A few logistics for the webinar today. Participants will remain muted during the course of the webinar, but if you have any questions, we invite you to ask those using the Q&A button that you'll see at the bottom of your screen. For any lawyers who are joining us on the webinar today, this program is approved by Greenberg Glusker for 1 hour of continuing legal education credit. A window with MCLE materials and instructions should open in your browser by the end of the presentation. These materials can also be accessed from the event page on our website at greenbergglusker.com. I'd now like to introduce our panelists for today. We have Elie Haddad, PE, who is a principal consultant at Elie and Aldrich in the Bay Area. Elie is a nationally recognized expert on vapor intrusion, having presented on the topic at conferences and as a faculty member at the Northwestern Environmental Training Center. He has supported legal matters for his clients regarding regulatory compliance, environmental assistance on real estate transactions, and litigation claims for various parties. Elie has a Bachelor of Science degree in General Science from Beirut University College and a bachelor's degree and master's degree in Civil Engineering from Georgia Tech. We also have with us today from Elie and Aldrich, Jennifer Boyer, who's a senior project manager. She has managed one of the United States' largest air sampling programs for a multi-party vapor intrusion Superfund site in the San Francisco Bay Area. She's reduced her clients' potential liabilities by cooperating with and balancing the interests of regulators, property tenants and owners, citizen groups, and various dischargers and their consultants. Her team has assessed approximately 100 commercial buildings for vapor intrusion, which is very timely for today. And Jennifer has a Bachelor of Science degree in Environmental Soil Science from Michigan State. With me today from Greenberg Glusker is Sherry Jackman. She's senior counsel in our environmental department, resident in Los Angeles. Her entire legal career is centered upon environmental litigation and compliance counseling, and she has participated in many significant matters involving vapor intrusion investigation, remediation, and litigation. She's been named a Super Lawyer Rising Star in the field of environmental litigation for the past 4 consecutive years. Sherry has a bachelor's degree from the University of California, Davis, and a joint JD and MBA from UCLA. And finally, I'm Brian Moskal. I'm a partner in the Greenberg Glusker Environmental Department. I've been practicing environmental law in Los Angeles for 15 years and represent clients in environmental litigation, real estate transactional, corporate transactional, and counseling matters with a focus on environmentally impacted properties and water and wastewater issues. I have a bachelor's degree in business administration from the University of Texas, and I got my law degree from Berkeley. So with that, I will kick it over to Elie to begin the technical portion of our presentation today.
Good afternoon, and thank you, Brian. It's our pleasure to present today. In the technical portion of today's talk, Jen and I will briefly define the vapor intrusion pathway. We will talk about some of the California regulations around it, how to assess it, and how we can correct it. Let's first start with what is vapor intrusion. Next slide, thank you. So when you are at home, when you are in an office, or at home like you are today probably, or an office, or in any occupied space, you are breathing air with chemical substances that could be coming into the space from the outdoor, through the ventilation system, or through cracks, or the windows in the walls, or they could be coming from occupant use of these products. But it also could be coming from intrusion through the subslab, from the subsurface. And it is this latter route, the vapor intrusion from the subsurface, that we will focus on today. Although in assessing that route, we also need to understand the indoor and outdoor sources to these substances. Next slide, please. Thank you. So as an example, indoor sources of chemicals, they can come from, see from the picture here, from dry clean clothes. And in that example, a specific chemical, perchloroethylene or PCE, is a common substance found in indoor air or outdoor air. It is used in dry cleaning processes. So chemicals can also be found in other household products, such as those are listed here in furniture, air freshener, cologne, and all of these. And some of you may have heard of trichloroethylene, TCE, and it is a subject of many probably articles that you've seen in newspapers, and that's because of its toxicity. But TCE, or trichloroethylene, is found in some cleaning products, but it's also found, if you own a gun, it's also found in gun cleaners. So if you do own a gun and you have one of those gun cleaner, look at the label, you probably will see TCE as one of the products from in that cleaner. So they do come through household products. We did find at one point in a building, in a commercial building, a TCE that we traced to insulation material that comes from Europe, from Belgium in that case. So you do have those in indoor air or indoor sources. So use of this product can be evaluated through some sniffers, what we call sniffers, or some instruments, and they do detect these chemicals in indoor air. And this is when we do a walk around the building and we specifically look for these kind of indoor sources. So this contribution or these chemicals that are used in manufacturing, used in household product, can also contribute to outdoor air. Benzene, for example, or PCE are pretty much ubiquitous in outdoor air. So our challenge is, how do we separate the contribution from the indoor sources or outdoor sources from the vapor intrusion pathway? From the subsurface environment. And this is what Jen is going to be covering in the next few slides. Next slide, please, Sherry. So why should you be concerned about vapor intrusion? And I know that Brian and Sherry will be going through this into much more details. So first of all, there's a concern about the potential health risks from exposure to what we call volatile organic compounds, or VOCs, through inhalation when you breathe it. So some of these compounds have been found to cause cancer or other health risks, and at low levels. So there's potential exposure from the vapor intrusion pathway to your own workers, probably, if compounds have been released in the subsurface in the past, even when you don't use these chemicals now anymore. So the potential exposure may expand also to homes, to other properties, if those compounds have moved from your current or past facilities beyond your properties and downgrading into those other properties. Some chemicals, such as the one I mentioned, TCE, trichloroethylene, they may have potential short-term health risks that could require a response action actually pretty quickly. And then vapor intrusion is also part of the ASTM standards for due diligence. So imagine if you are in an urban setting, you know, whether you are sitting now in San Diego area or in Sacramento or San Francisco Bay Area or Los Angeles, you know, imagine every corner, every block may have a gas station or a dry cleaning facility or some kind of manufacturing with chemical use. So there is a good chance that you may need to assess the vapor intrusion pathway during a property transaction. So, and finally, vapor intrusion may add to your liability portfolio on your company, and you may want to address that. It may affect your public relations, and if remained undressed, or unaddressed, then it may lead to some lawsuits. And there will be some of that talk with Sherry later on. So with that, I'll turn it over to Jen, and she's going to talk to you about how to assess and mitigate the vapor intrusion pathway.
Great. Thank you, Elie. So conceptually, vapors from the subsurface can enter structure from several potential pathways, such as cracks in the foundation or slab, or even through unsealed conduits. Aside from the subsurface, as Elie mentioned earlier, chemicals and background outdoor air can enter the building through leaks in the structures, like open windows, open doors, or even your HVAC system pulls in those vapors as a dilution mechanism. And as we talked about earlier, consumer products can also contribute to these chemicals in indoor air. Therefore, each one of the sampling methodologies that I'm going to talk about here are designed to take into account these potential pathways. So as shown, there's green dots on this figure, and we show the different types of sampling. There's soil gas, there's subslab, crawl space, indoor combined with outdoor air sampling. So first of all, we can collect soil gas samples, right? We can investigate the soil vapor in the subsurface. How we do this is we typically install a soil vapor probe close to the source. So for instance, as shown on this figure, if you're trying to sample that dissolved contaminant in the groundwater, then we would want to get close to that, not into the water, but close to that impacted groundwater. Then we collect the sample. To do so, we install a vapor probe, collect the sample. We seasonally sample as well because you want to check in variations or potential variations in concentrations. Additionally, we can also sample the crawl space samples. This is below the structure, so this is also good if you want to avoid going into buildings or houses. Many VI guidance assume that the measurement concentrations in that crawl space are equal to the indoor air or an attenuation factor of 1. So they'll be equal when we do our evaluation. We can also go directly inside the structure. We call this subslab sampling or indoor air sampling. One sampling device we use to collect those subslab samples is called a vapor pin system. This is the picture shown on the right. This is a really nice system that is easily installed by drilling a 1-inch diameter hole in the subslab. We hammer in the vapor pin device, then we actually collect the samples, and then we can either remove that vapor pin or leave it in place for subsequent subslab samples. The great thing about these subslab vapor pin systems is we can install them in areas that are low traffic areas, such as garages or in janitorial closets. In some cases, we actually just went to the corner of a room, pulled back the carpet, and installed the vapor pin system and sampled, pulled the probe out and filled it in and put the carpet back when we were done, added, So, and then we can also collect indoor air samples. This is important to collect them by placing the sampling apparatuses in pre-approved locations in typical breathing height areas. So this is when you're sitting at your desk, 3 feet off the ground, when you're standing up 5 feet off the ground. So we typically sample with SUMA canisters, although there are other different kinds of methodologies out there, Radiello, which is a passive system where you sample over duration of a few days, or etc. So to initiate the sampling with the SUMA cans, though, we would go into the buildings, place the canisters, open the valves. Those canisters are equipped with regulators. So the regulators allow you to do a predetermined volume of air into that canister at a flow rate. So we can either do like an 8-hour samples for commercial buildings, or if it's a residential building where you're trying to assess risk over a 24-hour duration, because that's what your residents could be, we would sample over 24-hour duration. And then finally, we go back, retrieve the samples, submit it to a laboratory for analysis. Also at this point in time, it's important for you to collect an outdoor air sample for comparison purposes. So you can actually say, now if my outdoor concentrations are equal to my indoor, then you're able to make that assumption and see what's on outdoor. Next slide, please. So this diagram is a simplified version of the CalEPA draft supplemental VI guidance that was issued in February 2020 of this year. So it provides a roadmap on how we can assess VI in these California sites. The document is lengthy and not finalized, but we try to summarize really what is going on with the nuts and bolts of this guidance document. So on the top left, step 1, we have to develop a sampling plan or approach, which gives you the details to implement that sampling. So you would want to have your types of sampling you want to do, your locations, what media you're going to use, etc. We can also prioritize certain buildings for larger sites. The work plan can specify soil gas samples or actually going directly into the indoor air samples. If the work plan specifies collecting the soil gas, then we would go to step 2, which step 2 is actually evaluating the VI for risk using soil gas. This appears to be the presumptive second step of the guidance document. The collected data is then compared to risk factors. So there are 2 risk factors when dealing with vapor intrusion or any other risk assessment that we would do. The first is estimated cancer risk. The guide here is to be less than 1 in a million. The other is a hazardous index, which estimates your non-cancerous potential risk. And here we calculate the calculated hazard risk needs to be less than 1. So if the risk calculations of step 2 from your soil gas sampling are less than those levels, then we can go to no further action is needed. However, if those numbers are above the risks indicated here, we have to do further assessment and actually go into step 3, which is evaluating the vapor intrusion. So this is really, we can collect soil gas, but vapor intrusion is what's happening, what's going inside of the building. So this means going inside of the structure and doing further evaluation by collecting indoor air samples, outdoor, like I talked about before, you always want to collect one indoor air sample, or not one, but your indoor air sample, and you want to have a complementary outdoor air sample as well. And you would also want to collect your subslab sample, subslab samples concurrently. So like I said before, you can bypass step 2 and go directly into collecting your indoor air, outdoor air, and subslab samples, but you needed to have that called out in your work plan. It has to be very clear, like all work plans need to be clear. So, so step 3 includes actually collecting the indoor, outdoor air samples. So this is where you would compare those results to your cancer risk of 10 to the minus 6 or your hazard risk of 1. These risks can be if those risks are less than those levels, then no further action is needed. However, if your risk is between 10 to the minus 4 and 10 to the minus 6, then there's a range of other options that we have, such as ongoing monitoring, VI mitigation, soil and groundwater remedy, further investigation that might lead to no further action as well. As part of step 3, the scope of work would be developed and approved by the agency. I think, in my bio, it's really important they get the agency on board and come up and develop a pre-approved locations, get them on board with, what the building use is, what your, contaminants of concern may be, etc. So, but if the risk is greater than 10 to the minus 4, you will have to do some vapor mitigation. So, like I mentioned earlier, there are many more details to consider here, and your consultant and environmental team should be familiar with the guidance and give you best practices. Next slide, Sherry, please. So this is important, the building walkthrough before your air sampling. So just so everybody knows, when we sample the soil gas samples or the subslab samples, those are actually the concentrations of the chemicals under the building. They are not, they provide an indication of what the potentials could be for vapor intrusion, but they don't actually give you that direct measurement. The indoor air samples, on the other hand, actually give you that direct measurement of the exposure to those chemicals. But they also measure they can measure what's coming into the subsurface and what's being contributed from indoor air chemicals. Like Elie stated earlier, there are so many chemicals that we use in daily activities that we wouldn't even know that contribute. So before we collect the indoor air samples, it's really important to do a building walkthrough and try to understand some of the contributions from those sources. I also like to invite the regulatory agencies to these walkthroughs. It's important for them to see the building and they're not just reading a document, or, so they understand the nuances of the building, they understand what's going on, etc. So I prefer to invite the regulatory agency, and you can then describe these pre-approved locations. That's how you get your pre-approved locations. So the information during the walkthrough that we seek is typically the building use, tenant operations, hours of occupancy, the building is unoccupied, occupied, is it being used for a warehouse, are they manufacturing something, is it a garage? So all these go into your work plan, and your sampling plan. So As part of that, we do a building survey for structural components. So is there an earthen cellar? Is there a basement? Do you have elevator shaft? Are there cracks in the subslab that will probably be contributing to vapor intrusion? Are there open conduits? Do those conduits need to be sealed? In this case, we're looking for any potential pathways that allows the vapors to enter the building from the subsurface. We perform the survey by identifying these sources. Sometimes we may take a screening tool like Lee talked about before. We like a PPB ray, HAPsite. It gives you an idea of what products could be contributing to these chemicals, right? So it is not uncommon to find these indoor air sources. Like Elie mentioned earlier, we found some TCE in insulation. Another recent activities, we found PCE, an adhesive that the developer was using in a banister of a newly constructed home. We obviously, before sampling, would ask that potential source, indoor air source, would be removed before sampling. Additionally, for commercial buildings, this is another key factor for doing your building walkthrough, is you bring in an HVAC contractor. They're the specialists. They will go in, they will assess things such as like how much outdoor air do you have being recirculated? This is usually a damper is opened. You can modify the opening of the damper or the damper is usually modified as part of the vapor mitigation, but understand how your building the outdoor air is coming in and how your HVAC system is actually operating. So we look at the distribution. Is your building pressurized? So we get those measurements as well. So it's also important for you to know how the HVAC system operates, because that could be a potential VI mitigation measure in the future. So next slide, please. So now we have all this data. What do we do now? So the California has screening levels for many indoor air, or for indoor air for compounds, right? So we screen those levels. They're not cleanup levels, but a lot of times they're default and they become so. As shown in this figure, for indoor air, if we collect indoor air, those results are compared directly to the California screening levels. We evaluate the data based on the potential health risk using the flow chart from before. When we collect background outdoor air samples, this data is compared to indoor air. If the numbers are similar, then we can make the argument that concentrations of indoor air are equal to the background and no further action is needed, even if these values exceed these screening levels, because we have publicly available data that shows that we have several chemicals in outdoor air, such as benzene, PCE. So important, again, to collect indoor air and outdoor air. And then last but not least, we have soil gas and subslab samples. Again, this is not the air we breathe. So we collect those samples and we compare them to the guidance document. We multiply the maximum detected concentration by a attenuation factor of 0.03. Brian will talk a little bit about that, but there's a lot of discussion about this attenuation factor of 0.003. This allows for us to consider the worst case scenario, right, of the concentrations. If we take the maximum, divide it, multiply it by this dilution attenuation factor, then that'll give us that concentration. We then can compare these concentrations to the screening levels and do your risk evaluation. So I think the other noteworthy item is that that attenuation factor is based on a data set from a nationally available data, and California is actually in the process of reassessing this attenuation factor, and maybe we could get some California specific values. Okay, so we've sampled, we've got the results, and unfortunately we have to do vapor mitigation, right? So this is engineering controls, essentially, that are put into place. There's a couple examples up on this slide. The first one on the left, this photo is an existing system, which is existing structure. This particular one is a residence, and it's actually retrofitted with a subslab depressurization system, or SSD system, that I may refer to it later. This is a similar concept to the radon-away fans. Actually, that's a radon-away fan that is being used currently there. We introduce a vacuum in the subslab environment via suction pit, and then we discharge it to outdoor air. These systems are simple and relatively cheap for smaller buildings. However, if you install it in large commercial buildings, you could have elaborate designs, regulator approval, and certain requirements for regulations. These treatment systems extract vapors, and they could cost up to $250,000 for large structures. So, could sliding scale residence versus commercial. So also we can mitigate combining that subslab system, whether it be active, meaning is there a fan on it, or passive, it's just there and venting to the atmosphere. And we can incorporate that with a vapor barrier. As shown on figure 2, this is actually a new construction that will be mitigated using a vapor barrier. This particular application is liquid boot, which we actually spray before pouring the slab. There are other types of barriers available out there, but this barrier provides a seal around all the penetrations, conduits, sewer, and we typically install this vapor barrier at a 60 mil thickness. After we install it, we also have to test the integrity of the vapor barrier via smoke test. Maybe more, maybe more than one smoke test too. The cost of this particular vapor barrier unit could range, but average is about $4 per square foot. Another mitigation is the one I talked about earlier, is actually modify the existing HVAC system. Sometimes we find that the older HVAC systems don't have outside air intake, so all we do is cut in a little outside, a little hole in the HVAC system, have our HVAC specialists retrofit it with a damper, etc., so we can actually flush the building. Sometimes we just increase the flow of outside air to have outside air volume higher. So that's opening the dampers. Ideally, you want to create a positive pressure in the building, so it creates a positive pressure to push the air out and minimize the potential for vapor intrusion. The cost for retrofitting an HVAC system can be one of the least expensive ones, and you already have the infrastructure available. But that could range between $5K to $10K. So, and then new development. So some of the developers are using these raised foundations, which is figure 4. They maximize land use as well as having this mitigation measure. The bottom floor is ventilated to the atmosphere for exhaust. So guess what? Vapor intrusion can't occur either, because the vapors will just go outside and it acts as a buffer. You still need to make sure your preferential pathways are sealed and elevator shafts, etc. So these are just a few vapor intrusion mitigation measures. And now I'll hand it over for Brian to describe some of the legal issues associated with vapor intrusion.
Thank you, Jennifer, and thank you, Elie. So that was a great overview of some of the technical aspects of vapor intrusion. Let's talk about how this comes up in sort of a real-world practical context. So one way in which this can come up is through the purchase and sale of property. So anytime a buyer is purchasing particularly commercial or industrial, but even multifamily property, it's always prudent to conduct a phase 1 environmental site assessment, which is essentially a file review and a site walk that can identify past uses of the property that may have caused environmental issues. So for example, if you've got a shopping center and you do a phase 1 and you discover that there was historically a dry cleaner on site, or maybe there's still a dry cleaner on site. Maybe the property was historically used for some form of electroplating or metal manufacturing. A buyer may then want to conduct phase 2 testing, where they actually start drilling holes and looking at chemicals that may be in the subsurface. So this is really, really important, by the way. We have a client right now in the San Fernando Valley who purchased some commercial industrial property in 1997 and failed to conduct any environmental due diligence whatsoever, and learned that he bought a multi-million-dollar problem because the property had historically been used for printed circuit board manufacturing, had very, very high levels of trichloroethylene in the subsurface, and unfortunately our client's now left holding the bag, and we're assisting with that. Not only can this be driven by a buyer, but it can also be driven by a lender. Banks are notoriously conservative, as they should be. They want to protect their collateral. And so oftentimes a bank will conduct its own phase 1 environmental site assessment before making a loan against property being acquired by one of its customers. Another context where this can come up is a non-sale loan. So this might involve, for example, a shopping center. We're assisting a client with this exact issue right now. It's a shopping center. The client has a marquee tenant who plans to move into a former grocery store space, And in connection with that, the client needed to take a loan against the property. They have a lot of equity in it. They needed a loan against the property to finance some of the tenant improvements for this new marquee tenant. And in the course of doing that, discovered that they had a potential vapor intrusion problem because of some dry cleaners that had historically been on site. And so, banks, if they're making a loan against existing property, they're going to do the same kind of analysis that they will do when making loans with respect to the purchase of property. This can also be regulatorily driven. So for example, you might have a situation where your neighbor is doing some of this investigation and they find some contamination and they look around and they see maybe that there historically was a manufacturing facility or a dry cleaner on your site next door. So you might find yourself getting an order from an agency like the Regional Water Quality Control Board or the Department of Toxic Substances Control. For example, under Water Code 13267, the regional water boards have very broad authority to require investigation of even potentially impacted properties. There's also Water Code Section 13304, where the water board has fairly similarly broad authority to require the cleanup of sites that are impacted, particularly in the context of groundwater impacts. Another way a regulator can become involved is, say you have a situation where you discover that you have a bit of an environmental problem. Maybe you do have some vapor intrusion going on, and you want to enter into a voluntary agreement with one of the regulators so that you'll do the necessary work to investigate and mitigate or remediate the problem. And at the end of that path, the regulator will give you essentially a clean bill of health, a no further action letter. So you might want to enter into a voluntary agreement with a regulator to do that work and to obtain that NFA letter. Maybe 10 years ago you did exactly that and you have your no further action letter, but there wasn't as much attention paid to vapor intrusion 10 years ago. The primary concern was impacts to groundwater and in particular drinking water. So regulators were concerned about these volatile chemicals moving down into the water as opposed to up into occupied spaces. So that has resulted in sites that had previously been closed and issued no further action letters being reopened by regulators to look at this exact issue. So that's another context in which this can come up. And finally, it can come up in the context of litigation. And Sherry's going to talk more about this in a few moments, but say you've got that same situation where neighbor starts doing some investigation on their property, they discover a potential problem, they start looking at your site, maybe they even convince a regulator to issue an order to you to investigate your site. And they come to the conclusion that this is really your fault, or at least the fault of maybe one of your former tenants or someone before you in chain of title. And they don't like that they've had to spend money to deal with this. And so they file a lawsuit under one of the environmental laws, federal or state, seeking their costs from you. In connection with that, they can require you to do some additional investigation of your property. And it may be prudent for you to do that anyway. So let's talk about some risk reduction strategies that can be used. So assume we're now in a situation where we know that we've got a subsurface environmental problem. Maybe we know that it's causing vapor intrusion into overlying structures. How do we allocate that risk, particularly in the context of purchase and sale and corporate transactions? So one way that risk can be allocated, and this is especially true in the real estate context, but it's also true in some of the corporate transactions I've worked on, where, for example, a company or maybe assets or stock or equity are being bought or sold. One simple way to deal with it is through a credit or a price reduction. So say you're buying impacted property, you've had your consultants take a really hard look, they estimate it's going to cost you $2 million to deal with this problem. So maybe you take that number, you add a risk premium, and you reduce the purchase price by that amount and let the buyer, or let the seller rather, walk away in exchange for that credit or that price reduction. Maybe you're not comfortable doing that. Maybe you're a little worried you're going to be left holding the bag. So another strategy that I've used literally within the past couple of weeks is an escrow or a holdback agreement to address mitigation and remediation costs. So what this looks like is seller is selling the property, buyer is buying the property. Some of the purchase money that would otherwise be received by seller gets put into a pot. And so, for example, we have a set of properties up in the San Fernando Valley. We helped a client sell recently for somewhere in the neighborhood of $35 million. The buyer was concerned about some fairly low levels of PCE that had been detected in indoor air at one of the properties. And so the structure that we used was a holdback agreement where $4.5 million was put into an escrow account, and the buyer is going to be able to use that for further investigation work as well as potential mitigation. So they may do some HVAC modifications, which Jennifer talked about, as well as potentially a subslab depressurization system if those HVAC modifications are not sufficient. So these agreements can be very complicated. You should certainly consult with counsel if you're interested in this option, whether you're on the buy side or the sell side. Another mechanism to allocate risk is a release. And this can be used in connection with some of the other strategies. For example, if there's a credit or a price reduction, maybe the seller is giving enough of a price reduction that they want to release, and they say, buyer, I'm giving you X million dollars. I want to walk away from this. I want you to release me from any claims. So that can be beneficial to the seller. It doesn't necessarily mean that you're released from third-party liability or government claims, but it will mean that the seller can't then come after you for some of these issues. An indemnity is a way where you could get protection from the seller or vice versa, or the buyer rather, or vice versa, if, for example, a seller really wants to buy their piece. So maybe they have implemented a credit or a price reduction. Maybe there's even a holdback or mitigation, a holdback account for mitigation expenses. Maybe there's a release, but maybe the seller wants to be fully protected by the buyer, for example. And so the buyer can give an indemnity to seller whereby they say, if you're subject to any claims in the future, whether it's by third parties, neighbors, the government, we will cover you for that. And again, you should absolutely consult with legal counsel before entering into any form of an environmental indemnity agreement. There's also environmental insurance out there. So environmental insurance is a very specialized product. It's not off the rack like your property or liability insurance. It's heavily negotiated. You need a specialized broker who deals in environmental insurance and knows the market. And you also want to have a lawyer who knows the environmental insurance market and the policy language. And what you can do here is you can insure against certain risks. Like, for example, if you've got a known contamination problem, you may be able to insure against off-site property damage claims. So you know you've got a problem on your site, but you want coverage in case your neighbor's been impacted and brings a claim against you. You can often get coverage for personal injury claims. So you know you've got a problem, and so the carrier might be willing to say, okay, if anyone such as an employee or an occupant brings a claim against you saying they got sick as a result of chemicals migrating up through the subsurface, we, the carrier, will cover you for that claim up to a certain amount and pursuant to certain terms and conditions. You're generally not going to be able to get cleanup cost coverage or the cost of mitigation for a known problem in the same way that a fire insurance company won't insure a burning building. They're probably not going to cover you for cleanup of known contaminants. But that can change if you get a no further action letter. Sometimes a carrier, in the context of an NFA letter, will give you coverage for cleanup claims if a regulator, for example, comes back and reopens the site. So those are just a few examples of the ways that you can use environmental insurance. And then the last risk management strategy is reps and warranties. You often see this in both real estate deals, but also corporate transactions where, for example, a seller will represent and warrant certain things about the environmental condition of the property. And if those reps and warranties turn out to be untrue, like, for example, if seller doesn't think there's an environmental problem and it turns out that there is, buyer may have recourse to indemnity through the purchase agreement. So let's talk a little bit more about California's new draft vapor intrusion guidance document. And so Jennifer alluded to this before, but one of the unfortunate aspects, although there are some benefits, and one of the things that the state is trying to do is really systematize vapor intrusion investigation, because you have problems right now where different agencies and even different regulators within the same agency are treating similarly situated sites differently. But among the problems potentially created by this new VI guidance is a dramatic increase in the cost of testing, mitigation, and remediation. So because of some of the things I'm going to talk about in a moment, a lot more sites are going to need to be evaluated for vapor intrusion, and the sites that are evaluated are going to be more expensive to deal with. And one of the big bugaboos here, and Jennifer talked a good bit about this, is the attenuation factor issue. So again, you know, you've got your soil gas concentrations from the subsurface. You multiply those concentrations times an attenuation factor to try to estimate what you've got indoors. So very basic example, say you've got 100 in the subsurface in soil gas, you multiply it by 0.03, which is the regulator's assessment that 3% of what's in the ground is going to come into the overlying building. And so that 100 in the ground, we're going to estimate as 3 in the building. And you have to use this number. You don't have a lot of latitude. Historically, you could hire a really smart consultant like Elie and Jennifer, and they could do, for example, what's called a Johnson and Edinger model, where they could look at a whole panoply of factors such as the age of the building, the type of the building, what shape is the foundation in, what kind of soil are we talking about, what's the chemical we're talking about, what's the soil porosity, the moisture level. You could look at all these site-specific factors, and you could estimate what's going on. And now you can't do that anymore. You've really just primarily got to use these attenuation factors. And as Jennifer talked about, if you're above whatever the risk threshold is, you're going to have to do vapor intrusion investigation, whereas you might not have had to do so before. Another big issue with the new VI guidance is renewed attention on sewer lines. So we've always looked at sewer lines, and this is especially true at dry cleaners, but it's true at a number of properties because sewer lines were sort of known conveyance mechanisms for hazardous substances. Some of your old mom and pop operations might just pour spent PCE down the drain, or maybe the dry cleaning machine would discharge rinsate water down the drain, but that rinsate water had low levels of PCE in it. So we've always known that sewer lines have potentially been an issue, but the regulators are really honing in on them as potential mechanisms for vapor intrusion into indoor air. So what they're saying is basically contamination that crosses pipes, whether it be in soil or groundwater, can actually infiltrate into those pipes and up into the subsurface as a completely different conduit from the soil. And so there's going to be a lot more money that's going to need to be spent evaluating sewer lines under the new VI guidance document. So with that, I'm going to pass it to Sherry to talk some more about some litigation issues.
Thanks, Brian, and thanks, Jen and Elie. So let's next talk about how do vapor intrusion issues dovetail with litigation. So in this chart, what we've done is highlight some of the key claims that are brought with respect to vapor intrusion issues. The orangish yellow ones are federal claims, CERCLA and RCRA, which most environmental lawyers practice with. And then the blue ones are state law claims, strict liability, negligence, wrongful death, nuisance, and trespass. And not surprisingly, there aren't a ton of cases that have been litigated with respect to VI. So what we did was we collected the claims that are out there and just put them in this diagram so you can kind of see how the claims are being litigated. So we'll next talk about a series of 3 different cases that we found interesting and had some key takeaways that we wanted to share with you. The first case is called Trujillo versus Ametek, and I'll go ahead and frame the issue with a short video clip.
His eyes had swollen shut and his throat was closing up.
Parents say an aerospace plant next to their kids' school made them sick by dumping thousands of gallons of chemicals into the ground.
Team 10 troubleshooter Kristen Severance broke the news on 10news.com that a class action lawsuit had just been filed against the plant. Kristen, the lawsuit claims the dumping went on for some 20 years.
I want to show you how close these 2 buildings are. So this is Magnolia Elementary School. Right next to it is the aerospace plant. You can't get much closer. They actually share a property line. Now, this lawsuit that I just got my hands on claims that the plant dumped chemicals into the ground. Those chemicals are now going up through the ground and into the air of the school.
So the Magnolia Elementary School raised a number of issues with respect to VI. A lot of the stuff that we've already discussed is relevant here, but in the litigation, there were 4 state law claims initially brought by the students and teachers of Magnolia Elementary against the former aerospace facility successor. So the first claim was negligence, which, as many of you know, is a simple carelessness type claim. And the problem with respect to VI and negligence is, in order to get negligence, you have to have damages. And if you are a plaintiff, you may not have a present injury. You may just have been exposed and therefore not necessarily have a condition that is readily visible now. So the way the plaintiffs in this case got around that was by pleading that they had increased risk of harm, and that was successful in a motion to dismiss. The second claim was gross negligence, which is a higher standard. It's extreme indifference or reckless disregard for safety. And the court looked at this claim in the pleadings and said, yes, they have successfully pled this claim. because 20 years have passed and they've been investigating the site for so long, but not any remediation has been done, and therefore the gross negligence claim was allowed to proceed as well. The third claim was public nuisance, and the challenge typically with this type of claim is that you have to allege, if you're a plaintiff, a special injury that is kind of different in terms of its impacts on the plaintiff than the general public. And the way that the claim was allowed to survive in this case was by saying, well, we share this property line with the former Ametek facility, and therefore proximity alone gives us a special injury and allows us to proceed with this claim. And the final state law claim was strict liability, which is typically for ultra hazardous activities or unusual activities. But because the nature of the activities here were degreasing of metal parts, which is actually pretty customary in the aerospace industry, the court said there's no basis for a strict liability claim here. This is not an ultra hazardous activity. A few other issues that we found interesting, I'll just share one or two. The statute of limitations, oftentimes these sites have been open sites for many years. This site was first identified in the 80s. And so, of course, the defendant said, you've known about this site for a long time. There have been all kinds of documents about this site. Your claim is barred, it's too late. And the plaintiff said, well, it wasn't until this 2015 public meeting that we first learned that there was some potential wrongdoing and had a duty to investigate. And so therefore they were able to plead delayed discovery and get past a statute of limitations issue. On punitive damages, quickly, that was not barred in terms of the claim for punitive damages because of just the quantity that was dumped. And then the last issue pertains to spoliation of evidence or destruction. And for the consultants out there, this is a really important one. So the plaintiff said, Ametek, you turned on your SSD system prior to letting us conduct baseline samples. We don't even know what the conditions were prior to the turn on of this SSD system. You've spoliated or destroyed evidence. The court actually said, yes, you have, but said, well, it's not that prejudicial because there have been samples taken at the site for many years. And so rather than giving you this really bad consequence of spoliation and adverse inference, we're just going to make you undo it and take apart the SSD system and let the plaintiffs go back in time and collect these samples so that they can see what the baseline looks like. So really, really interesting case. Lots of opinions came out from this one. The second case is just a really brief kind of takeaway, and it's a reminder to litigants that oftentimes a problem with vapor intrusion sites is that they're not fully characterized. We don't have enough data to say, where is the vapor? Where is it migrating? Where is it creating an indoor air problem? So there's some tools for both plaintiffs and defendants to utilize in both litigating and defending vapor intrusion claims. These tools in federal courts are Rule 34 and Rule 45, which generally allow for inspection and sampling on properties. So if you're in the case, you can actually take samples of the other side's property potentially using these rules. And you can also take samples of neighboring third-party sites using Rule 45. 34 is typically for parties, 45 is typically for non-parties. So these are actually really powerful tools. And if you're a defendant, you might say, there's a third party that's responsible, not me. We should be entitled to go ahead and take samples. So this case is Vogenthaler versus Maryland Square in the District of Nevada. And please note that these claims actually have state law or these rules in federal court have state law analogs. So whether you're in state or federal court, similar rules exist to address this type of issue. The last issue we'll talk about on the litigation front is a very commonly used provision of RCRA, which is a federal hazardous waste law that in subsection B permits a private party to bring a lawsuit against a responsible party who has contributed, I'll just try to summarize this, it's long, to the handling, storage, treatment, transportation, or disposal of waste. And the keywords are that may present an imminent and substantial endangerment to health or the environment. So this is a citizen suit provision. Anyone can invoke it if you meet this criteria. So there were a number of early unsuccessful RCRA claims under pertaining to vapor intrusion. This West Coast Home Builders versus Adventist case was very similar to SPPI Somersville, so I've put them together in this chart. In both cases, there was a property owner adjacent to a landfill that claimed that contamination in the landfill migrated downward into the subsurface and then migrated to the neighboring adjacent property, giving rise to a vapor intrusion problem. Both sites in these cases were under DTSC orders, and so the plaintiff said, well, you're not really entitled to relief under RCRA because you're already getting relief through DTSC. You have orders issued to you. They're telling you exactly what you need to do. You don't have a RCRA claim. And the plaintiff said, well, DTSC is not addressing vapor intrusion, and we actually have these sort of loose, rough plans for unspecified future development. And therefore, we should be able to get a RCRA injunction to mitigate and relieve us from this vapor problem. The court said no, your claim is tossed on summary judgment and found, in fact, that DTSC was already addressing the harm and that the risk, if any, was contingent on development and wasn't actually imminent and substantial. So we actually represented a client, and there's some takeaways from these cases, but I just told you all of them, so I'm going to just include this in your deck so that you can go back and look at them later and talk about a case that we were involved with that dealt with these exact principles. So in our case, I'll just start out with this map. The northern site is called the Tamkin property, and the southern site is called the former ORC property. Our client formerly owned the southern portion of this site, but sort of had a problem because volatile organic compounds had been released at the Tamkin site and were migrating down this way to our property. And so even though both sites, similar to the cases I just described, were under an order, it didn't really matter because every time, Tamkin could potentially clean up their site, their contaminants could migrate onto our site, creating this issue of recontamination, as we called it. And the agencies actually had required Tamkin to remediate off-site portions, including this railroad, but they actually were not doing that at the time, and the regulators weren't really enforcing that very strictly. So we pled that groundwater contaminants were migrating from the Tamkin site towards the ORC site, our client site, the former site. And even though, just as in the other cases, there was agency oversight over both sites, we added this additional allegation, which is that, well, we have a proposed residential development over the plume, not us actually, but the buyer of the property, which was at the time a university. And so we pled, well, there's a vapor intrusion issue because they're planning on developing residences on this former ORC property. They're the new owner and there's an endangerment. So we had a RCRA claim. And our key pleading number one was the regional board hasn't adequately addressed the endangerment. So even though you might say, well, you're under an order, you're good, we said, no, there's a failure to require offsite cleanup and there's this recontamination scenario that's happening so that we can't ever effectively clean up this site. And then the second key pleading was that there was a pathway, because in the prior case, there was no structure. There was no, imminent plan to develop a structure. Here we said, there's going to be a pathway. There's this indoor air pathway where the building's going to go in, and there's also a drinking water pathway. So we successfully defended on a motion to dismiss of this RCRA claim using the principles involved in those other authorities. So those are a few cases that we have looked at recently on vapor intrusion. There's more, they're all very interesting. And with that, I will open it up to questions for all of the panelists. And thank you so much for your time.
Thanks, Sherry. So we do have a few questions in the queue. So the first one, going forward, beyond a phase one, how much additional upfront due diligence do you recommend before even entering into a commercial real estate transaction? And so I would say a couple of things about this. Number one, Phase one is essential both because it can identify problems, but also because it can provide you with some liability protection under the federal Superfund law, even if there's a problem down the line, as long as you check the box of going in eyes wide open by doing a phase one and complying with some other requirements. You need to make sure that your phase one consultant is reputable, because Sherry and I can't tell you how many times we've looked at a phase one where the consultant concluded no quote unquote recognized environmental conditions, but there was a dry cleaner on site or there was a neighbor with a problem. So make sure that you've got a good phase one consultant and a good phase one. But the additional due diligence that you may want to do is really going to be context dependent. But if the phase one identifies some what we call RECs, recognized environmental conditions, then you've got to think about whether you want to do possibly some targeted subsurface sampling. And one thing that can give you a lot of information without a lot of hassle or cost would be some targeted soil vapor sampling. Because these chemicals in particular are volatile, oftentimes a vapor sample can let you know if there's a problem, not just where the sample's drilled, but sort of in the vicinity. So I don't know if Elie has anything that he'd like to add to that, or Jennifer or Sherry.
You did pretty well. Cost-wise, it may be, you're thinking about 20, 30K, for a phase two. And it could be more than that depending on the size of the property.
Great, thanks, Elie. Someone asks if you'll get the slide deck, and we will make sure that's available to you if not already. How does one know, and Elie, I'll look to you and Jennifer on this, how does one know if the indoor sample result is correct when concentrations can be dynamic?
That's a good question. There are studies that have shown that concentrations in indoor air, not only in indoor air, but also in soil gas, could change. So if you collect a one-time sample, such as an Isuma canister, it may change a month later or 2 months later. And there are also some studies that for indoor air, the highest concentrations are, and this is from some researchers, that the highest concentrations are measured during the winter months. So there are ways to address that. The guidance specify that you collect samples seasonally to take a look into that. So it's not just a one-time sampling event. So if you have a soil vapor probe, you install it and you collect a sample and you come back and you install some seasonal samples. It could be the same thing with indoor air where you have to do that as well. There are other ways where you can sample continuously if that's needed, or if you get access to do that. And then also the Radiello sample allows you to collect samples on average over 3 or 7 days. So it's not just a snapshot of 8 hours or 24 hours. So there are ways to do that. I would say the best thing to do is define that in the work plan and make sure that the regulatory agency has proofs of what you want to do.
Great. Next question. What is your opinion of the much greater risk potential that CalEPA has assigned to ethyl benzene in particular?
So the regional board and through the OEA, they change or they continue to study the toxicology of chemicals, and they change. Sometimes they go up, sometimes they go down. So if the screening level of a certain chemical, such as in this case ethyl benzene, goes down, then that means more work for you. Basically, it's going to lower the standards by which you have to do an action.
Great, thanks. And the last question for the moment. Could you talk about remote telemetry monitoring of mitigation systems and how that might close risk gaps for owners and insurers?
I could take that. So yeah, we have quite a few SSD systems that have, remote monitoring that we can call in, or it gives us call outs, and it's able to measure, what's going on through the system. So we have implemented remote monitoring systems, and as for how they help us to understand how the system's operating and ensures that the tenants or owners are, the system is continuing to operate.
Great.
Elie, anything?
I would add to that it also minimizes our access
in.
to the property. You know, because it's you can do it on your desktop or send you alarm, so we don't have to keep on going there and basically not trespass, but you know, get permission to access the property all the time.
Yeah, getting access agreements can often be a big challenge that can delay investigation work. We did just have one more question come in. What is your take on petroleum VI? The questioner has had sites where the plumes have gone farther than EPA suggests.
Sure, I follow that. So with the vapor intrusion, whether it is petroleum or VOCs or chlorinated, there is the guidance provides for a buffer zone that goes beyond the plume itself. So when you if you have a plume in the groundwater, you add a buffer zone of whatever feet it is in order to assess your vapor intrusion. If I'm reading that question correctly. So you have to, and that buffer zone uses the, you know, whether it is preferential pathways such as conduits or uncertainty in defining the plume. So it's all combined in that. And that changes from guidance to guidance depending on the state.
Great. And then one more, and this will be our last question for today because we are at the bottom of the hour. If you know that there's a vapor intrusion or subslab vapor issue, say from a dry cleaner, but it's below the residential screening level, do you disclose it in connection with the purchase and sale agreement? And how do your clients deal with this in the transaction? So what I would say about that is I would definitely disclose it, because even if the concentrations are below the residential screening level, the screening levels can and do change. And you would really want to avoid a situation in the future where the buyer claims that they were defrauded because they weren't told about this issue. In addition to the screening levels changing, it could be that the samples were taken, the concentrations are low, but maybe there's later sampling in another part of the property and the concentrations are higher, and the buyer says, well, I would have done that sampling if I had known. So I would generally recommend to a client, depending on the circumstances, that they do disclose that. But if the levels are below residential screening levels, I would see if we could get from the buyer a full release, you know, under the theory that there's not a lot of risk here. You could also probably insure around it, but it may not be necessary depending on the concentrations. So we're a couple of minutes over. I'd like to thank Elie and Jennifer and Sherry for a wonderful presentation. Thank you all for being here. Hopefully everyone stays safe and healthy during these challenging times. And if we haven't already, we will be sending the slide deck out as well as CLE materials to participants. So thank you very much.
Thank you.